Does the judiciary need sentencing guidelines? Some lawyers share their opinions. Also showing on the program today, a recap of the top legal stories in the news, plus our interview segment with the senior advocate of Nigeria, Moyo Inigbanjo, on the 2016 budget impasse and whether a legal solution is possible. Hello and welcome to the program. I am Shola Shieli. Over the years, the public perception on the sentencing of individuals, especially those facing corruption charges, is that there's no consistency in some of the judgments. Some sentences, even on similar facts, have been severe, while others have been lenient. Last week, Tuesday, the FCT High Court, in partnership with the United Nations Office on Drugs and Crime, organized a roundtable on the draft Federal Capital Territory Sentencing Guidelines Practice Direction, designed to help the court achieve greater consistency in its judgments and more predictability in the judicial process. But what do lawyers make of this move to have sentencing guidelines and uniformity? Is it achievable across the country? And what are some of the factors that might work against it? Some lawyers share their opinions with Law Weekly.
Nigeria is a federation, as you are well aware of. We have federal laws. We also have state laws. Now, these federal and state laws, states have their own criminal laws. Like in Lagos State here, for example, we have the criminal laws of Lagos State. We have the Administration of Criminal Justice law of Lagos State. At the federal level, we just have the Administration of Criminal Justice Act of Nigeria 2015 that was just passed by the National Assembly. We have other federal laws as concerning criminal matters. Now, each of these laws prescribe particular punishment for offenses as the case may be. Now, the judge has discretion on how to carry out the sentencing, depending on all of these factors. So all of these factors come to play when it comes to sentencing. Because don't also forget here too that it is the duty of the prosecution to prove the guilt of the defendant or accused person as the case may be. And that also plays in the mind of the judge. Now, you also have issue of, is a man a first-time offender? Also comes to play. So these are factors that come to play when it comes to sentencing.
If you ask a layman in the street what he feels about the way people are sentenced over crimes committed, you see they will have varied opinions. Some people do not like the way, I that is talking to you now do not like the way sentencings are done in our criminal dispensation in this country. But there's one thing we should know in law. You cannot talk about sentencing guideline. You cannot talk about a uniformity of sentence without talking about the legislation that backed it up. Our criminal dispensation of justice need to be the laws and legislations regulating our criminal dispensation of justice need to be amended. It needs to be amended for us to achieve our heart desire on it.
Justice is a worthy enterprise, and it's something that whenever you want to, if you want to achieve justice, you need the people's position as it relates to. Okay, has justice been done in this state? And don't forget, justice must not only be done, but must be seen manifestly to have been done. So when people are involved, there is need for you to ensure a kind of, not uniformity as it were, but meeting the reasonable expectation of the people. And that is why you may have to get sentencing guideline. If this is this, give this. If the factual situation is this, or you give this sentence within this range. That should not be that you are counseling or you are abolishing the discretionary powers of the judge. No. But of course, you're more like thunder white horse called discretionary powers. You're more like tame it and give them a kind of a breadth they cannot go beyond.
I think that having a code, as you're saying, a sentencing guideline as a code to guide judges across the board, across the nation, will be very vital, so that these seeming cases of discrepancy that have given the impression in our country especially that when a judge hands down a sentence that is not heavy, it's because he's been tipped or bribed. When the sentence is heavier, it will be maybe the poor man is involved and he couldn't give. So I think a sentencing guideline will go a large extent, to help. and also to also allay this suspicion, and I think it is very, very workable.
Different reactions there, but please feel free to join in the conversation and share your views with us. Let's now go to the courtrooms to track some of the top legal stories in the news.
We begin with the report that the Code of Conduct Tribunal has adjourned to the 10th of May. Last week, the tribunal chairman, Mr. Danladi Umar, dismissed an application by the Senate President asking him to hands up the case on grounds of alleged bias. Dr. Bukola Saraki has since approached the Court of Appeal to challenge that move on the grounds that it did not meet the requirements of law. The Senate President has also pleaded not guilty to an amended 16-count charge filed against him. The amended charges replaced the initial 13-count charge preferred against him. 3 of the charges, amongst other things, accuse the Senate President of failing to declare ownership of an American Express card account and a property in Lagos. The defense team asked for more time to study the new charges, and the tribunal conceded to an adjournment. On the next adjourned date, the defense team is expected to continue with the cross-examination of the first prosecution witness, Michael Wetkas. At the Federal High Court sitting in Abuja, the trial of the former Minister of Interior, Abba Moro, suffered a setback as the judge handling the case withdrew from the matter. Justice Angoli Chikere, who has been handling the case, says she is returning Mr. Moro's case file to the Chief Judge of the Federal High Court for reassignment to another judge. She said she was doing so for personal reasons. The former Minister of Interior is standing trial for allegedly defrauding immigration applicants of over 676 million naira. In another development, the trial of the National Publicity Secretary of the People's Democratic Party, Mr. Olisa Metu, was stalled following his application to seek medical attention. Trial Judge Justice Okonabang adjourned the case to the 17th and 18th of May after an oral application by counsel to Mr. Metu to the effect that his client came from a hospital bed to honor the court date last week Wednesday. Mr. Metu is facing a 7-count charge of fraud and money laundering. The case against the self-acclaimed leader of the indigenous people of Biafra, Mr. Nnamdi Kanu, did not go on at the Federal High Court, Abuja. Justice John Soho turned down his application for a stay of proceedings on the grounds that it was not based on facts. Mr. Nnamdi Kanu had filed the application seeking the stay pending the determination of an appeal he filed to challenge his trial. Justice Soho has, however, ruled that the trial will continue unless there is an order from the appeal court. The trial has been fixed for June the 20th. In Lagos, a Federal High Court presided over by Justice Babs Keomi last week Wednesday fixed the trial of the Managing Director of the Nigerian Airspace Management Agency, Mr. Ibrahim Abdul Salam, and 6 others for the 12th of May. The NAMA MD is facing a charge of 6.8 billion naira fraud before the court. He is charged alongside 4 other members of staff of the agency, the wife of one of them, and 2 limited liability companies, Roundvale Investment Limited and Maltech Travels and Tours Limited. They were all brought before the court by the EFCC on a 24-count charge, and after pleading not guilty to the charges, they were granted bail in the sum of 20 million naira each, with 1 surety each. They have, however, been unable to meet their bail conditions, and at the instance of their lawyers, the court granted them an adjournment to enable them perfect their bail conditions and prepare for their defense. And we round off with the case against Senior Advocate of Nigeria, Mr. Ricky Tarfa. Justice Aishat Okpesonwu of the Lagos High Court has fixed the 22nd of June for the commencement of his trial. The court fixed the date after dismissing the preliminary objections he filed to the 2-count charge of obstruction of justice and attempting to pervert the course of justice by bribing a judge. The court resolved all the issues raised by the senior advocate against him and held that the prosecution had successfully made a prima facie case against him. His application to quash the charges was also found to be lacking in merit.